So we need to talk about some critical decisions which struck down a state's rifle and magazine ban, which are now up for appeal. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. Brownells, you guys know, is an amazing company. They support the Second Amendment. They support what we do here on the channel. So again, just an amazing company. They do great things in the community. If you're interested, check them out. You can use my code SCHOLAR10 for 10% off of your orders. And again, thank you to Brownells for sponsoring this channel. Now, as I mentioned in the intro, in this video, we're going to be talking about what is now happening in some critical cases which challenge various state bans on so-called assault weapons, simply rifle bans, and also magazine bans as well. Recently, we received another huge decision from a district court judge, Judge McGlynn, which struck down the Illinois Protect Illinois Communities Act, also known as PICA. This all comes after the Supreme Court denied emergency review in these Illinois rifle and magazine ban cases. Despite that, Judge McGlynn in these cases recently struck down the law on the final merits, finding that they do in fact violate the Second Amendment. Illinois has now appealed these cases to the 7th Circuit once again, and the biased 7th Circuit once again decided to grant the state a request for a stay on that decision. I also want to talk about the California magazine ban case, which is known as Duncan, and then also the California assault weapon ban challenge, which is known as Miller. And we need to talk about how these radical courts, not just in the 9th Circuit, but the 7th Circuit, are doing everything in their power to avoid ruling on these cases. Now, you might remember that originally in multiple Illinois cases, a district court judge issued preliminary injunctions that were intended to halt the enforcement of PICA. However, the state of Illinois then appealed those preliminary injunctions to the 7th Circuit, and on review, a liberal and biased 3-judge panel in the 7th Circuit overruled the granting of those injunctions. Now, in coming to that decision, the 7th Circuit concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they used the military use test, which again does not align with what the Supreme Court has said in cases like Bruin, Heller, McDonald, and others. That then led all of these cases for the first time to seek immediate Supreme Court intervention. But like I mentioned, the Supreme Court at the end of their last term denied emergency review to these Illinois cases. Now, despite that, there was a statement in the denial from Justice Thomas where he stated that if the 7th Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. He went on to state that the court must not permit the 7th Circuit to relegate the Second Amendment to a second-class right. Now, while the preliminary injunction appeals were pending in Illinois, and while they were being reviewed by the Supreme Court, the lower court judge there was moving these cases towards a final merits decision, and he reviewed and issued those decisions. Judge McGlynn once again found that PICA is unconstitutional and struck it down on the final merits. However, in that decision, he decided to stay the enforcement of his order for 30 days so that Illinois could appeal to the 7th Circuit because we all knew that's what they were going to do. Illinois, of course, did appeal and request the stay, which was granted by the 7th Circuit. In that order, the 7th Circuit stated that defendants' request for a stay largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunctions. A decision at the preliminary injunction stage is not dispositive when plaintiffs later seek permanent relief. Our opinion indicated some matters that needed further exploration, but the analysis in Bevis shows that the laws have enough support to remain in place pending the final resolution of the plaintiff's suit. Every other court of appeals that has addressed the validity of similar legislation in the wake of Bruin has come out the same way as Bevis. The laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in other circuits for the district court's disposition lends strength to a conclusion that the Illinois statutes should remain in force until the final appellate resolution. So the 7th Circuit found that since they had issued a prior decision and other circuit courts have upheld similar rifle and magazine bans, the state ban here in Illinois should remain in effect during the entire appeal. They also told Judge McGlynn that his prior ruling had some deficient explanations in it, and they expected him to revise it because they believed it was not clear enough. So the lower court did issue a new decision, reissued it in accordance to what the 7th Circuit wanted, but it doesn't really change anything because the 7th Circuit decided to put a blanket stay on this case until they reach their final decision. Now, some may think that the plaintiffs should have challenged the stay request and maybe seek a new emergency relief from the Supreme Court to try to remove that emergency stay. But right now, the best strategy, in my opinion, would be to simply move this towards a final merits, because the Supreme Court has not wanted to get involved at an interlocutory posture in this case and other cases as well. We all know that the Seventh Circuit is going to issue a horrible ruling. They have decisions already on this case and others where they're upholding these rifle bans and magazine bans based on the military use test. I suspect that they're going to do the same thing. So really the best option right now is try to move this through the process as fast as possible, reach a final merits decision on rifle bans and magazine bans, and then try to elevate that once again to the Supreme Court on a final merits like Justice Thomas wanted. But really, a lot of this hits on a larger issue that we're seeing right now with anti-gun circuit courts in their review of rifle and magazine bans. If you take a look at some of these other bans in other states, like California's ban on rifles and magazines, which were challenged in the Ninth Circuit, there are clear signals that these courts will stall these decisions for as long as possible. The California rifle ban case that we followed for a long time, the Miller versus Bonta case, which was reviewed and decided by Judge Benitez multiple times and ultimately struck down the California rifle ban, that has been elevated to the Ninth Circuit. It was re-reviewed by a 3-judge panel. Oral arguments were held back in January 2024. I believe it was January 26, 2024. And that case has now been on hold for over 404 days. They decided to put the Miller decision on hold until the Ninth Circuit en banc panel rules and decides the Duncan magazine ban case. So for 404 days, the Miller California rifle ban has been on hold. Now, the Duncan case was taken, as a comeback case by the en banc panel, and they tried to do that because they wanted to issue their own decision. Well, back in March 30th of 2024, they held oral arguments in this case, but since then, again, we have no decision, and it's been around 349 days to this point where they have already heard this case, but not issued a decision. So what does this all tell us? We all know that these anti-gun circuit courts will do everything in their power to stall these cases when they don't want to rule on the merits. And when they ultimately do rule on these cases, they will try to twist the Bruin analysis as much as possible. And they will do that to meet their anti-gun agenda. So their first strategy is to stall these cases for a very long time. And when they finally do issue their decisions, it's going to be a decision that does not align with Bruin and is going to be an outright defiance to what the Supreme Court has said. The 7th Circuit and 9th Circuit are well known for doing this type of thing. There's also a general hesitation right now from some of these circuit courts and some of these judges to not want to issue final merits decisions because they know after that these cases will be elevated to the Supreme Court. And a lot of these cases, like Duncan, have already been GVR'd after Bruin. And, you had a new decision from Judge Benitez in light of Bruin striking down the California law. And the Ninth Circuit does not want this to get elevated to the Supreme Court and, get a new analysis in light of Bruin. The plaintiffs in the Illinois case will try, of course, to push this case through as fast as possible, but in many ways are kind of at the will of the circuit court, like we've seen in the Ninth Circuit. And even after the 3-judge panel rules in the 7th Circuit on the Pica case, this could go en banc. The 7th Circuit could take this en banc on their own if they wanted to and try to once again play the stall game like the 9th Circuit did as well. And also keep in mind, even when we get this, final judgment in the 9th Circuit from the en banc panel, or maybe even from the 7th Circuit, that doesn't mean that once this gets to the Supreme Court's also going to move fast on this. We've now seen with the Maryland Snope case and the Ocean State Tactical case, there's been relists 5 or 6 times now for a new conference, for a new consideration. So even the Supreme Court is dragging their feet a little bit on this issue, and we haven't got a firm, signal from the Supreme Court that they want to address the issue of rifle and magazine bans. So unfortunately, that's where all these critical rifle and magazine ban cases are currently at. We're keeping our eyes on the Supreme Court Snope and Ocean State Tactical considerations because those would be the ones that are most important, that would impact what's going on in Illinois, in California, and would impact the review of these circuit courts. But unfortunately, without the Supreme Court taking action on those and really pushing these circuit courts to rule on these issues, the tactic has become that the circuit courts like the 7th Circuit and the 9th Circuit will try to stall these cases for as long as possible and then issue a decision that does not align with Bruin. So not only are we having to fight against anti-gun states that put in place these types of bans, but we also have to fight against anti-gun circuit courts that want to play kind of judicial games. So that's kind of what's going on. I know a lot of people are asking me what's going on with the California cases with magazines and rifles, what's going on with Illinois. That's what's going on right now. A lot of these courts and a lot of these, judges are trying to stall these decisions for as long as possible. But of course, if we get any more information As things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you guys for watching. Don't forget to like, comment, subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.